I start off this judgment with a quotation from Mohammed, acting judge as he then was, in the matter of Atchison versus the state, where he said, "An accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice," unquote. The question that I'm faced with in this matter is whether the applicants in this matter are being kept in detention as anticipatory punishment, calling for the court to intervene and order their admission to bail, or whether the ends of justice require that they be kept in detention pending the outcome of their criminal trial. There are 6 applicants in this matter, namely Sacky Shanghala, James Hatuikulipi, Pius Mwatelulo, Nghipunya, Otneel Shuudifonya, and Phillipus Mwapopi. The state is the respondent. On 27 November 2019, Mrs. Shanghala, Hatuikulipi, and Mwatelulo were arrested on charges of corruption, money laundering, and fraud. Mr. Nghipunya was arrested on 17 February 2020, also on charges of money laundering and fraud, whilst Mrs. Shuudifonya and Mwapopi were arrested on 21 December 2020. The latter two were also arrested on charges of corruption, money laundering, and fraud. All 6 applicants have since the time of their arrest been in detention. During June 2020, Mr. Nghipunya unsuccessfully applied for bail in the Magistrates Court for the District of Windhoek. He appealed to the High Court of Namibia against the decision of the magistrate not to admit him to bail. On 28 October 2021, the High Court dismissed his appeal. Mr. Nghipunya has again approached this court with a fresh bail application. He says on new facts. The new facts, according to him, are that the investigations are now complete, which was not the case during June 2020 when he brought his initial bail application. The state has disclosed the content of the docket, and the disclosure runs into some 80,000 pages. Further, that considering and studying the disclosure, particularly the documents to be relied upon by the state, he is now better suited to comment on the strength of the state's case. Since his arrest on 17 February 2020, to date, there has been no trial in sight, which is almost 2.5 years after his arrest, and there are also 42 new counts which had been added, incorporating and largely overlapping with the previous charges. I will later in this judgment, albeit briefly, deal with Mr. Nghipunya's application for bail on new facts. The remainder of the applicants, that is Shanghala, Hatuikulipi, Mwatelulo, Shuudifonya, and Mwapopi, are all first-time applicants for admission to bail. Before I consider the grounds on which the applicants rely for their admission to bail, and the grounds on which the state opposes the admission of the applicants to bail, I find it appropriate to briefly, not in detail, restate the legal principles applicable to the question of whether or not a court can grant bail. The legal principles are, let me repeat. The starting point is a Criminal Procedure Act 1977. That is section 60 subparagraph 1 of the Act provides as follows, and I quote, "An accused person who is in custody in respect of any offense may at his or her first appearance in a lower court or at any stage after such appearance apply to such court, or if the proceedings against the accused are pending in the High Court, to that court to be released on bail in respect of such offences, and any such court may release the accused on bail in respect of such offence on condition that the accused deposits with a clerk of the court or the registrar of the court, as the case may be, or with the officer in charge of the correctional facility where the accused is in custody, or with any police officer that at the place where the accused is in custody, the sum of money determined by the court in question. In the matter of Nghipunya versus the state, Justice Sibeya opined as follows, and I quote, "An accused person who is detained has the right to apply to bail, but this falls short of entitlement to bail. Bail can therefore not be claimed as of a right. Hence, the need for its application and to establish that the applicant is a candidate worthy of being granted bail. Where the application for bail is refused, the applicant may subsequently apply for bail based on new facts when such new facts are said to exist." Unquote. An applicant for bail bears the specific onus to prove on a preponderance of probabilities that the interest of justice permits his release. This means that an applicant must specifically make out a case. This means that an applicant must specifically make out his own case and not necessarily rely on the perceived strength or weakness of the state's case. In so doing, an applicant must place before court reliable and credible evidence in discharging these honors. In the matter of State versus Atchison, Justice Mohammed outlined the considerations in the court. In the matter of State versus Atchison, Justice Mohammed outlined the considerations which the court must take into account in deciding the issues of whether or not to grant bail in the following terms, and I quote, "Is it more likely that the accused will stand his trial, or is it more likely that he will abscond and forfeit his bail? The determination of that issue involves a consideration of other sub-issues such as A. How deep are his emotional, occupational, and family roots within the country where he is to stand trial? What are his assets in that country? What are the means that he has to flee from the country? How much can he afford the forfeiture of the bail money? What travel documents does he have to enable him to leave the country? What arrangement exists or may later exist to extradite him if he flees to another country? How inherently serious is the offense in respect of which he is charged? How strong is the case against him, and how much inducement there will be, therefore, for him to avoid standing the trial? How severe is the punishment likely to be if he is found guilty? How stringent are the conditions of his bail, and how difficult would it be for him to evade effective policing of his movements? The second question which needs to be considered is whether there is a reasonable likelihood that if the accused is released on bail, he will tamper with the witnesses or interfere with the relevant evidence or cause such evidence to be suppressed or distorted. This again involves an examination of other factors such as whether or not he is aware of the identity of such witnesses or the nature of such evidence, whether or not the witnesses concerned have already made their statements and committed themselves to give evidence, or whether it is still the subject matter of continuing investigations, what the accused's relationship is with such witnesses, and whether or not it is likely that they may be influenced or intimidated by him, whether or not any condition preventing communication between such witness and the accused can effectively be policed. The third consideration to be taken into account is how prejudicial it might be for the accused in all the circumstances to be kept in custody by being denied bail. This would again involve the examination of other issues such as the duration or the period with which he has already been incarcerated, if any, the duration of the period during which he will have to be in custody before his trial is completed, the cause of any delay in the completion of his trial, and whether or not the accused is partially or wholly to be blamed for such a delay. The extent to which the accused needs to continue working in order to meet his financial obligations, the extent to which he might be prejudiced in engaging the assistance of the legal assistance for his defense, and ineffectively preparing for his defense if he remains in custody, and the health of the accused, unquote. Apart from this, Section 61 of the Criminal Procedure Act as amended vests the court with a discretion to refuse bail if, in the opinion of the court, it is in the interest of the public or the administration of justice that the accused be retained in custody pending his trial. Notwithstanding that, the court is satisfied that it is unlikely that the accused, if released on bail, will abscond or interfere with any witness or for the prosecution or with a police investigation. Those are the legal principles. Having set out those legal principles, I next tend to consider the grounds on which each applicant seeks to be released on bail. I find it appropriate to point out that the first three applicants in this matter, that is Mr. Shanghala, Hatuikulipi, and Mwatelulo, opted for motion proceedings to launch their application for bail. This is by notice of motion supported by affidavit. This court has, in the matter of Nghipunya and Nghipunya, this court has, in the matters of Nghipunya versus the state and Nghipunya versus the state, indicated that there is nothing irregular or improper with that approach. I now start to consider the grounds upon which Mr. Sacky Shanghala seeks to be released on bail. Mr. Shanghala, in his affidavit in support of his application for bail, contends that he anchors his application for bail on several weighty factors which fall in three broad categories, namely, given the circumstances in which he finds himself, denying him bail will constitute a violation of his fundamental rights. The second broad category is that the current criminal proceedings are the outcome of an unlawful investigation by the Anti-Corruption Commission. And thirdly, having regard to the ordinary considerations that are taken into account when deciding whether or not to release an accused on bail, there is no cogent reason not to release him on bail. I will briefly set out these alleged weighty factors in the ensuing paragraphs of this judgment. The violation of Mr. Shanghala's right, or let me rather say the alleged violation of Mr. Shanghala's rights. In his affidavit, Mr. Shanghala contends that he was arrested on 27 November 2019. He continued and contended that by the time that he deposed to this affidavit in support of his application for bail, he has been in custody for some 2 years, or more than 24 months. He further contends that there is, however, no indication as to when the trial itself will begin. 2 sets of criminal proceedings have been joined, ensuring that this will be a lengthy trial that will not be finalized for some years. This fear, it is the fear of the lengthy trial, he contends, is reinforced by the revelation that the state has lined up up to 338 witnesses. Mr. Shanghala thus continues and contends that denying him bail will constitute a violation of his rights under Article 7, that is the right not to be deprived of personal freedom except in accordance with the procedures established by law. Article 8, the right not to be subjected to cruel, human and degrading treatment. Article 12, the right to a fair trial. Mr. Soni, who appeared on behalf of Shanghala, argued that if Mr. Shanghala is denied bail, Such denial of bail will be inconsistent with the other rights referred to by Justice Oosthuizen in the Gustavo matter. The position now is that, so argued Mr. Sony, that unless Mr. Shanghala is granted bail, the period of custody will be extended to several more years without him having been found guilty of any offense. This would not accord with Article 12, which provides that criminal trial shall take place within a reasonable time, failing which the accused must be released and that all persons are presumed to be innocent until proven guilty. The second broad category is the unlawful investigations by the Anti-Corruption Commission. Mr. Shanghala further contends that the more serious charges that he faces, namely racketeering and money laundering, are based on investigation by the Anti-Corruption Commission, which it is not empowered to investigate, and whose investigation in respect of these offences and charges is accordingly unlawful. And that little reliance can be placed on the allegations and biased views of the main witness whom the state called to oppose the grant of bail. Mr. Sony further argued that Mr. Andreas Kanyangela, the main witness for the state in the opposition of the bail application, was nakedly hostile to the applicants and especially to Mr. Shanghala. Mr. Kanyangela, he argued that Mr. Kanyangela did not take the court into his confidence on several important issues. He exercised powers that he did not have and inexplicably refused to exercise powers granted to the Anti-Corruption Commission that would have assisted in uncovering facts, thereby presenting a more balanced picture and considerable shortening the length and cost of the investigation. Counsel further argued that Mr. Kanyangela failed to provide any proper explanation for his and the Anti-Corruption Commission's alleged clearly one-sided approach to the entire investigation, and in particular, why the Anti-Corruption Commission did not exercise the quite potent powers that the Anti-Corruption Act grants to the Anti-Corruption Commission investigators. He thus submitted that the most reasonable inference that the outcome of the investigation, let me repeat, and I quote, the most reasonable inference is that the outcome of the investigation was to visit maximum prejudice on the applicants on several fronts: violation of their rights, starting with the ending of their freedom, depriving them of their assets, and undermining their dignity, and in the case of the first applicant, his political reputation, unquote. The ordinary considerations. Mr. Shanghala indicated that he is an adult male who has been a faithful servant of this country for more than 2 decades. He states that he suffers from hypertension, asthma, and sleep apnea, which requires that he uses a CPAP machine, and he is also required to take medication daily. He alleges that his conditions are being exacerbated by his being kept in custody for more than 2 years now. He further states that he is the father of 2 5-year-old children, has an aged father and grandfather who depend on him, and that they are adversely affected by his prolonged absence. He continued and contended that his continued incarceration means that he is unable to perform the responsibility for the greater Ihua, Haidullah, and Shanghala kin and folk. In his affidavit in support of his application for bail, Mr. Shanghala proclaimed his innocence and his intention to stand trial. He further stated that he shall not evade justice, that he shall not interfere or tamper with the witnesses of the state, and he shall not interfere with the administration of justice. That's in brief a summary of the grounds put forward by Mr. Shanghala. I now move to Mr. James Hatuikulipi. Mr. Hatuikulipi, in his affidavit in support of his application for bail, also contends that he anchors his application for bail on several weighty factors which fall in the same broad same three broad categories that were enumerated by Mr. Shanghala. I will therefore not repeat those grounds here, except for the personal circumstances of Mr. Hatuikulipi. Mr. Hatuikulipi indicated that he is an adult male who has extensive commercial and farming business interests in Namibia. He states that he suffers from hereditary hypertension, which requires daily medication and balanced diet. He has 3 surviving siblings, one who resides in the United Kingdom, one in Windhoek, and one in Otjiwarongo. He pointed out that while he has a South African residence, he is not a South African citizen. He indicated that his identification document and passport have been confiscated by the Anti-Corruption Commission authorities. In his affidavit in support of his application for bail, Mr. Hatuikulipi also proclaimed his innocence and his intention to stand trial. He said that he shall not evade justice, that he shall not interfere or tamper with witnesses of the state, and that he shall not interfere with the administration of justice. In summary, that's Mr. Hatuikulipi's grounds for seeking to be admitted to bail. I now move to Mr. Pius Mwatelulo. Mr. Mwatelulo, in his affidavit in support of his application for bail, also contends that he anchors his application for bail on several weighty factors which also fall in the same 3 broad categories that were enumerated by Mr. Shanghala. I will therefore also again not repeat those grounds, except for the personal circumstances of Mr. Mwatelulo. Mr. Mwatelulo indicated that he was ordinarily resident at number 493 Albertros Street, Hoogland Park, Windhoek, Namibia. He has a 4-year-old daughter who lives with her unemployed mother, but is dependent on him for support. He alleges that in addition to the 4-year-old baby girl, he also looks after his 6-year-old nephew, 2 cousins, and his aunt. He states that he created and grew a business known as Otwafika Investment CC, which employs around 90 people and whose employment hinges on him being able to steward that business. In his affidavit, Mr. Mwatelulo also proclaimed his innocence and his intention to stand trial. He said that he shall not evade justice, that he shall not interfere or tamper with witnesses, and that he shall not interfere with the administration of justice. I now move to Mr. Mike Nghipunya. As I indicated earlier in this judgment, this is the second attempt by Mr. Nghipunya for him to be released on bail. He says this is based on new facts. Justice Salionga, in the matter of Shielongo versus the state, quoted with approval a passage from State versus Peterson, where she said, and I quote, "When, as in the present case, the accused rely on new facts which have come to the fore since the first or previous bail application, the court must be satisfied, firstly, that such facts are indeed new, and secondly, that they are relevant for the purposes of the new bail application. They must not constitute simply a reshuffling of old evidence or an embroidering upon them." Unquote. I am satisfied that the facts which Mr. Nghipunya contends are new facts, and which he has set out, did not exist. I am satisfied that the facts which Mr. Nghipunya contends are new facts, and which he has set out, did not exist as at the hearing of his bail application in June 2020. Those facts are thus new facts, entitling him to launch another bid to be released on bail. I will thus consider all the facts that Mr. Nghipunya has placed before me, new and old, and on the totality of the facts, will come to a conclusion whether or not to admit him to bail. Mr. Nghipunya was in the witness box for a period exceeding 8 court days. It is thus not an easy task to summarize his testimony and cross-examination without unnecessarily burdening this judgment. I will therefore only highlight the aspects in his testimony which in my view are relevant for me to make a determination with regards to his application to be admitted to bail. Mr. Nghipunya testified that he is a single 37-year-old male, resident of 171 Ikhabu Street, Rocky Crest, but currently detained at the Windhoek Correctional Services, Windhoek, Namibia. He testified that he has lived in Namibia all his life and has no relatives outside Namibia. He further testified that during the year 2014, he was seconded by the Public Service Commission to the Namibia Fishing Corporation, that is Fishco, to act as its chief executive officer. He acted in that position until 2016, when he was appointed as Fishco's substantive chief executive officer. Mr. Nghipunya furthermore testified that at the time when he assumed the role of acting chief executive officer in 2014, Fishco faced a plethora of challenges, including operational difficulties where its factory would shut down periodically due to such operational challenges. Fishco also had a lot of debt with financial institutions such as the Development Bank of Namibia and the government of the Republic of Namibia, and that the financial institutions were also calling on their debt from Fishco. The company was in desperate need of a rescue plan, and that is when he was tasked to devise a turnaround strategy. He testified that his achievements as Fishco are impeccable and that he has managed to turn around the fortunes of Fishco. Mr. Nghipunya further testified that during November 2019, when the Fishrot scandal broke to the public, he was in Tokyo, Japan, on official business. He contends that although he had an opportunity, if he had so wished, to abscond, he did not do so, as he is a law-abiding person with faith in the Namibia judicial system. He testified that as he was never tempted to run away, as he had no reason, he was never tempted to run away, as he has no reason to do so. He further testified that following the arrest of some of the co-accused in this matter on 23 and later on 27 November 2019, he was also aware that he was implicated in the Fishrot scandal. He was still able to travel in and out of Namibia, but he never absconded. Mr. Nghipunya furthermore testified that on 14 February 2020, the Anti-Corruption Commission informed him that the summonses were ready and that they were ready to hand them over to him. To that end, and upon legal advice, he made arrangements for him to report to the Anti-Corruption Commission on Monday, 17 February 2020. He was aware, even at the time, that his arrest was imminent. He acted lawfully and did not abscond, nor did he do anything to jeopardize the state's investigation. He then arranged to go to the ACC offices for his arrest on 18 February 2020. He testified that he knew long before his arrest of his impending arrest. He contends that this was an indication that he was cooperative and has no intention of absconding investigations against him. Mr. Nghipunya further testified that the record disclosed by the state is voluminous, especially following the joint of the Fishco and Namgomar cases, and therefore the opportunity to consult is even more critical. He contends that following the receipt of the state's disclosure, he has no reason to abscond, as he strongly holds the view that the state's case is based on the misunderstanding of his functions as the chief executive officer of Fishco, and that he is desperate to clear his name in a court of law, as he has complete faith in the Namibian courts. He contends that for the first time, he has received a list of statements in the state's disclosure, and having gone through some of those statements, he says he has no reason to interfere with those witnesses. He testified that a statement was obtained from his brother, and he will ensure that he does not interfere with his brother. Mr. Nghipunya further testified that during his tenure as Fishco's chief executive officer, he had clean financial reports, and same were presented to the minister, who then submitted it to cabinet. It was a requirement that independent auditors perform the audits, and that the financial books of Fishco were audited for every year that he was in office. And such audits were undertaken by a firm of auditors, T.F. Fender Associates, which is a firm based here in Windhoek. He testified that no irregularities were identified. He further testified that an audit by an external firm such as T.F. Fender Associates was not an exercise between the Chief Executive Officer and the independent auditors alone. The auditors engaged the board, the senior management of the organization, and the finance department staff, as they have powers to request information from anyone within the entity. Mr. Nghipunya further testified that the minister responsible for fisheries and marine resources was the functionary empowered by the Marine Resources Act of 2000 to determine policy, to allocate quotas, and to designate governmental objectives for Fishco. He proceeded and testified that there were two types of quotas allocated to Fishco under governmental objectives. At times, such quotas were for Fishco's own utilization in order to pursue its own commercial goals. In many instances, such quotas were also allocated to Fishco. The other type of quota was under governmental objectives, which were allocated to Fishco as an agent of the government and of the Republic of Namibia for the benefit of other parties. These quotas were not part of Fishco's own assets, the testimony went. Mr. Nghipunya further testified that it was Fishco's financial policy that revenue derived from quotas allocated for the benefit of third parties not to be reflected in Fishco's books, as it was not part of Fishco's assets. However, there was still a requirement that the utilization of those quotas be subjected to full transparency requirements, checks and balances, and to give full accountability to the owner of the quotas, being the government of the Republic of Namibia. And this is why Fishco still subjected the allocation of and utilization of those quotas to annual audits. Mr. Nghipunya further testified that in respect of each quota that was allocated to Fishco, he accounted for each metric ton, and the revenue derived from such quota was utilized as directed by the minister responsible for fisheries and marine resources. He testified that to the best of his knowledge, the minister allocated the quotas exercising his powers contained in Section 3, Subsection 3 of the Marine Resources Act of 2000. He also testified that Section 3 of the Marine Resources was also complied with, that Fishco was designated as such entity, in that there was a designation agreement concluded between the Minister of Fisheries and Marine Resources, and which was gazetted under Government Notice number 99 in Government Gazette of 6017 of 27 May 2016, as amended by Government Notice 14 in Government Gazette of 6308 of 15 May 2017. Based on this testimony, Mr. Nghipunya in essence denied that he committed any offense and argued that he is confident that he will at the trial be able to defeat the charges leveled against him, and that the state has no prima facie case against him. Mr. Nghipunya furthermore testified that he is willing and prepared to be admitted to bail on the following conditions: that he be ordered to report himself to the Ochomuse police station every Monday and Friday between the hours of 7 o'clock and 1900 hours, that he be ordered not to leave the district of Windhoek without the prior knowledge of the investigating officer or any designated police officer, that he be ordered to surrender his traveling documents, passport, to the investigation officer, and further that he be prohibited from applying for any new travel document pending the determination of the main criminal matter, that he be ordered not to interfere with the police investigation or the states in witness in the main criminal matter, that he be ordered to pay and deposit an amount of Namibia $200,000 as bail, or in any such other conditions practicably reasonable that this court may deem appropriate. I now move on to consider the grounds advanced by Mr. Otneel Shuudifonya. Mr. Otneel Shuudifonya testified that his full names are Otneel Nanditonga Shuudifonya, and he is 32 years of age. He further testified that he was born at Okaonde village in the Ohangwena region of northern Namibia. He further testified that he was ordinarily resident at F3221, extension 7, Otjiwarongo, Republic of Namibia. He testified that he has 3 children, the oldest being a 4-year-old girl, the second youngest being a 1-year-old girl, and the youngest being an 8-month-old baby. He further testified all 3 children will live with their mother, but the mothers are unemployed and are thus dependent on him for support. He furthermore testified that he is employed by the Otjozondjupa Regional Council, but his salary has since been suspended, and as such he has no other source of income. As regards his business activities, Mr. Shuudifonya testified that he is the sole member of a close corporation titled Njako Investment CC and another entity titled Fine Seafood Investment Trust. Mr. Shuudifonya further testified that Saga Seafood and Fine Seafood Investment Trust entered into transaction that is independent from any governmental body. He therefore contended that he accordingly does not see how Fine Seafood Investment can be linked to the fishing quotas that were allocated to Fishcore. As regards Njako Investment Close Corporation, he testified that Njako provided consultancy services to a company known as Low Key Investment Pty Limited, and thus the funds that flow from Low Key to Njako were for legitimate services rendered by Njako to Low Key Investment Pty Limited. On this basis, he contends that the state has failed to demonstrate a prima facie case against him. Mr. Shuudifonya also proclaimed his innocence and his intention to stand trial. He testified that at the time when the news broke that a warrant for his arrest had been issued, he was in the northern part of the Republic of Namibia, near the Angolan border. He continued and stated that despite that, he, 7 days later, handed himself over to the Anti-Corruption Commission and was arrested. He further testified that after his arrest, he cooperated with the Anti-Corruption Commission investigation. He further testified that he shall not interfere or tamper with witnesses, and that he shall not interfere with the administration of justice. That's a summary of the grounds on which Mr. Shuudifonya is seeking to be admitted to bail. Mr. Phillipus Mwapopi. Mr. Mwapopi testified that he is an adult male, age 33 years. He further testified that he was born at Swakopmund, Namibia, and that he was ordinarily resident at F6441, extension 16, Commersdal, Windhoek, and that he is married and has a 12-year-old daughter who is still attending school. He furthermore testified that he is employed by the City Police Department in the city of Windhoek as a constable, but has since January 2021 been on suspension without remuneration, and as such he has no source of income. He furthermore testified that he is currently a PhD student. As regards his business activities, Mr. Mwapopi testified that during 2016 he floated and registered a close corporation named Wanakadu Close Corporation, of which he is the sole member and managing member. Mr. Mwapopi further testified the payments which Wanakadu received from Fishco were for goods, and the goods were identified as dried fish, which it sold and delivered to Fishco. He testified that the payments that Wanakadu received from Low Key Investment Pty Limited were for consulting services rendered by Wanyemba Investment Trust and rendered to that company. He testified that Wanyemba Investment, is it Trust or CC? Okay. He testified that Wanyemba Investment Trust delegated the payment of its invoices to Wanakadu CC. He accordingly denied that the state has a prima facie case against him. Mr. Mwapopi in his testimony also proclaimed his innocence and his intentions to stand trial. He testified that at the time when the news broke out that a warrant of his arrest has been issued, he was also, like Mr. Shuudifonya, in the northern part of Namibia near the Angolan border. He continued and stated that despite that, he also 7 days later handed himself over to the Anti-Corruption Commission and was arrested. He further testified that he shall not interfere or tamper with the witnesses and that he shall not interfere with the administration of justice. Having briefly set out the grounds on which the applicants are basing their application to be released on bail, I now turn to the basis on which the state opposes the admission of the applicants to bail. The grounds on which the state opposes the granting of bail are that the charges are serious and they involve a criminal syndicate or enterprise, that there is a strong prima facie case against the applicants, that there is a likelihood that the applicants may abscond and not attend their trial, that there is a likelihood that the applicants will interfere with witnesses, and that it is not in the public interest to release the applicants on bail, that it is also not in the interest of the administration of justice to release the applicants on bail. I will briefly outline these grounds in the ensuing paragraphs. In opposition to the application for bail, the state called Mr. Kanyangela, who testified that he was the chief investigating officer and who narrated to the court the nature of this ACC's investigation and the result of forensic analysis done on behalf of the anti-corruption. This was done by a local auditing firms on samples collected from the applicants' communication devices such as mobile telephones, desktops, and laptops. Mr. Kanyangela also narrated and backed up his narration with invoices and copies of emails of and bank accounts of the flow of funds between the Fisco and some of the accused or applicants. The narration states that the revelations from the investigation points out the flow of funds between Fisco, Namgoma, companies which form part of the Samheri group, and Novanam on the one hand, and on the other hand, the 6 applicants and three other co-accused who are not part of this bail application and close corporations, trust, and companies in which the applicants and their co-accused have one or other interest. The state is further in possession of more than a dozen witness statements, some of which implicate the applicants of the offenses of corruption, money laundering, racketeering, and fraud. The investigation officer, that is Mr. Kanyangela, further narrated to court that all the funds that passed hands and flew between the entities mentioned in the preceding paragraphs derived from the allocation of fishing quotas that were in terms of the Marine Resources Act allocated by the then Minister of Fisheries to achieve stated governmental objectives. Mr. Kanyangela further informed the court that those funds did not achieve the objectives for which they were intended, but ended up in the pockets for the personal use of the 6 applicants and their co-accused. Based on that testimony, the state submitted that it had made out a prima facie and strong case against the applicants. The likelihood that the applicants may abscond. Mr. Kanyangela, during his testimony, testified that although the applicants in this matter proclaim that they will not abscond or interfere with witnesses, these averments must not be taken seriously because the applicants now know the seriousness of the charges that they are facing. He testified that they are facing charges involving more than 317 million Namibia dollars, and the sentences that are likely to be imposed if they are convicted will be heavy and lengthy custodial sentences. That knowledge is an incentive to the applicants to abscond, testified Mr. Kanyangela. Mr. Kanyangela also testified that Mr. Shanghala is facing charges. That's now the likelihood, under the heading of likelihood of applicants will interfere with case or witnesses. Mr. Shanghala testified that Mr. Shanghala is facing charges of defeating or obstructing or attempting to obstruct the course of justice because he allegedly sent one of his co-accused to remove documents and physical evidence relating to this case from his residence at R13B, Berg Street, Klein Windhoek. As regards Mr. Hatuikulipi, Mr. Shanghala testified that Mr. Hatuikulipi has a pending case in the District Magistrate Court for the District of Windhoek, wherein he is facing charges under the Anti-Corruption Commission involving bribery, as well as obstructing the course of justice relating to the allegations that he and his co-accused, acting in concert and common purpose, attempted to bribe members of the Anti-Corruption Commission. Shanghala testified that Mr. Hatuikulipi allegedly sent a certain Mr. Iyambo to pay an ACC investigating officer an amount of 250,000 Namibia dollars in exchange for the officer returning some of the exhibits in the form of bank cards, some belonging to Mr. Hatuikulipi and others belonging to Mr. Mwatelulo, which bank cards were seized from them during the investigation of the matter. Mr. Shanghala proceeded and testified that a certain Jason Iyambo denied the charge of bribery but pleaded guilty to the charge of obstructing the course of justice, and he was convicted and sentenced to a period of 18 months imprisonment, which he has served. Shanghala testified that during the forensic analysis of Mr. Hatuikulipi's communication device, the investigation officer found information which shows that prior to his arrest, Mr. Hatuikulipi was in the process of hatching plans to manufacture documents in order to disguise the real reasons for a payment of an amount of $4 million to a company known as Tundavala in its offshore account. He further testified that that amount was indeed paid into that company's account held in Dubai in the United Emirates. He further testified that amount has actually been moved out of that account and its whereabouts are now unknown. During his testimony, Mr. Shanghala referred the court to a witness statement by a certain Jose Ramon Camano, who stated that during November 2019, Mr. Nghipunya contacted him to sign a consultancy agreement between Skeleton Coast Trawling Pty Limited and Wanyemba Investment Trust, and to backdate it to 2017, and which agreement sought to portray Wanyemba Investment Trust had provided services of maintenance, catering, vessel management, and repairs to Skeleton Coast Pty Limited, and claiming that the agreement would offer him and Novanam a form of safety. In the witness statement, Mr. Camano went further and stated that Mr. Nghipunya, after he was arrested, further contacted him from prison from a telephone that did not display a number and requested him to sign the agreement. He further stated Mr. Nghipunya sought financial assistance from him. In the statement, Mr. Camano further stated that a certain Oti called him and provided him with the banking details in which he had to pay the money that was requested by Mr. Nghipunya, and the said Oti also sought meetings with Mr. Camano. During the proceedings, it became clear that the Oti being referred to here is the fifth applicant, Mr. Otneel Shuudifonya. The last ground on which the state opposes the bail is that it is not in the public interest or in the interest of justice to release the applicants on bail. As regards public interest and the interest of justice, Mr. Shanghala simply stated that in consideration that the state has a strong case against the applicants and their co-accused, the seriousness of the offenses and the substantial amount of money involved in this matter, there is a likelihood of heavy sentences being imposed. It is thus not in the public interest or in the interest of the administration of justice for the applicants to be released on bail, said Mr. Shanghala. Having shortly set out the grounds on which the applicants base their application to be admitted to bail and the grounds on which the state opposes the application for bail, I now proceed to consider whether or not the applicants have discharged the honors resting on them. I embark on the discussion now. I, with reference to the cases of State versus Pinheiro, State versus Donza, State versus Gustavo, indicated that an applicant for bail bears the onus specifically to prove on a preponderance of probabilities that the interest of justice demands that he be permitted and be released on bail. I furthermore indicated that this means that an applicant must specifically make out its own case and not necessarily rely on the strength of witnesses of the state's strength. The applicants in this matter, and in particular, the first, second, and third applicants, allege that the fact that they are denied bail infringes their constitutional rights, particularly the rights conferred on them by Article 7, 8, and 12 of the Namibian Constitution, and the rights outlined by Justice Oosthuizen in the Gustavo matter. In the matter of the Disciplinary Committee for Legal Practitioners versus Sleskan Makando and the Law Society, and Sleskan Makando versus the Disciplinary Committee for Legal Practitioners and others, this court, per Justice Parker, had the following to say. In considering the first respondent's constitutional challenge based on Article 12, Sub-Article 1 and Article 18, I keep in my mental spectacle the following tried principles of our law. 1, constitutional challenges in general, and 2, constitutional challenges of a provision of a statute in particular. Under the constitutional challenges in general, it has been said that the person complaining that a human right guaranteed to him or her by Chapter 3 of the Constitution must prove such breach. He cites as authority for that proposition the matter of Kobe Alexander versus the Minister of Justice and others. And before it can be held that an infringement has indeed taken place, it is necessary for the applicant to define the exact boundaries and content of the human right and prove that the human right claim to have been infringed falls within the definition of that right. Under the item 2, that is the constitutional challenge of a provision of a particular statute, he said the inquiry must be directed not only at the words used in formulating the legislative provision that the applicant seeks to impugn, and the correct interpretation thereof to see whether the legislative provision in the instant case Article 12, Sub-Article 1 and Article 18 of NAN has in truth been violated in relation to the applicant. He again cites the matter of Kobe Alexander versus the Minister of Justice as authority for that proposition. I close quotes. With that, I find that it thus follows that the applicants in their affidavits and in their oral evidence had to furnish facts in the form of evidence pertaining to the nature of the violation of their constitutional rights. As regards the evidence which the applicants had to put before the court in their affidavits and in oral evidence, I echo the words of Kum Luben, then acting judge in the matter of Radebe versus others versus the Eastern Transvaal Development Board, that the allegation, and in this case I say the allegations that the constitutional rights are infringed in the founding affidavits and in the oral testimony are simply conclusions of law. They are at best applicants' inferences. They are secondary facts, with the primary facts which they depend on having been omitted. In the matter of Wilcox and another versus Commissioner for Inland Revenue, Schreiner, Judge of Appeal, explained the concept of primary facts and secondary facts as follows. Facts are conveniently called primary when they are used as the basis for inferences as to the existence or non-existence of further facts, which may be called in relation to the primary facts inferred or secondary facts. In the instant cases, The applicants had to place facts before the court on which they base their conclusion that their constitutional rights are being violated or infringed. They did not do that. What they did is that they pleaded legal results and parroted Article 7, 8, and 12 of the Constitution. I am of the further view that the applicant's reliance on the Gustavo matter is misplaced. I say so for the following because in that matter, the learned Judge Oosthuizen simply enumerated the rights guaranteed under the Constitution, but does not tell the reader of that judgment how the rights have been violated. It must be remembered that in this matter, all the applicants were arrested on the strength of warrants of arrest issued by a judicial officer, and the legality of the warrants of arrest was tested in this court, meaning that their arrests are neither unlawful nor arbitrary, but in accordance with the law. This court had the following to say in the this court, per Justice Olin, had the following to say in the matter of State versus Duplessis and another. It is apposite, I quote, "It is apposite here to deal briefly with continuous and it seems selective emphasis placed by some accused person on their legal representatives on certain sections of the Namibian Constitution and certain fundamental rights such as the right to liberty of the subject, a fair trial, and the principle that an accused person is regarded innocent until proven guilty. These very important fundamental rights are, however, not absolute but circumscribed and subject to exceptions. The particular right relied on must be read in context with other provisions of the Constitution, which provide for the protection of the fundamental rights of all citizens or subjects, which provides for the responsibilities and obligations of the subjects, for the maintenance of law and order, for the protection of the very same Constitution in which the rights are entrenched, and for the survival of a free, democratic, and civilized state. As to the fundamental right for a fair trial, it seems obvious that there can be no fair trial if the trial itself cannot take place because the accused have absconded. It is also inherent in the Namibian Constitution that the state must protect the subject as well as the Constitution and the state itself by combating crime and criminals, by apprehending alleged criminals and taking all reasonable steps to ensure that they will stand their trial. When the subject is detained and his or her rights are infringed, he or she suffers inconvenience or is otherwise prejudiced by such detention. This can never be done arbitrarily, but only in accordance with the law and procedures provided for such detention, and at the same time providing safeguards. Furthermore, the common law provides that the subject has an action for damages where his detention or prosecution is malicious or otherwise unlawful. In addition, it is the practice of the courts when sentencing an accused person to take into consideration in his or her favor of the period of detention prior to conviction. Such laws are in the interest of the public and the interest of the administration of justice." Unquote. For the reasons that I have set out in the preceding paragraphs, I've come to the conclusions that the applicants have not discharged their honors resting on them to demonstrate that their continued incarceration is in violation of their constitutional rights. Mrs. Shanghala, Hatuikulipi, and Mwatelulo also based their application to be released on bail on the basis that the current criminal proceedings are the outcome of unlawful investigations by the Anti-Corruption Commission. I indicated earlier in this judgment that Section 60 of the Criminal Procedure Act 1977 confers on an accused person who is in custody the right to apply to the relevant court to be released on bail. Whilst it is true that detained persons such as applicants have certain rights which are protected by the law, the proper course to follow when such rights are violated is a different matter. You know what must happen? So just do the honorable. Even if we meet on street, don't ask me for the phone. I'm not going, it's not in my hands. I am of the view that upon a proper construction of Section 60, subsection 1 of the Criminal Procedure Act, a person whose detention has been pronounced lawful and in the interest of justice cannot simply resort to a bail application merely because the pre-detention procedures are flawed. It is, however, available to such person consent to challenge the detention before a court of law as being unconstitutional or unlawful. I pause here to observe that in this matter, Mr. Soni, who appeared on behalf of Mrs. Shanghala, Hatuikulipi, and Mwatelulo, relying on answers extracted from Mr. Kanyangela during cross-examination, urged and invited this court to take into consideration what this court remarked and said about the Anti-Corruption Commission in the matters of Hailulu versus the Director of the Anti-Corruption Commission and State versus Lamek. I must say, I decline that invitation for the following reason. Article 12 of the Namibian Constitution guarantees everybody, this includes the Anti-Corruption Commission, a fair trial. If I have to make findings about the impropriety of the Anti-Corruption Commission's conduct, such findings must be based on allegation properly placed before court and in terms of which the Anti-Corruption Commission is also given an opportunity to refute such allegation. A finding about the reputation of a body which was not given any opportunity to defend itself is grossly unfair. I accordingly find that the second and weighty considerations relied upon by the first three applicants for their admission to be granted bail are irrelevant to the question of whether or not they must be admitted to bail, and I equally find that the first to third applicants have also failed to discharge the onus resting on them to demonstrate that they are worthy of being admitted to bail. I now proceed to consider the applicant's application based on what they term as ordinary considerations. The first consideration being whether it is more likely that the applicants will sustain their trial or whether it is more likely that they will abscond and forfeit their bail. The applicants, all 6 of them, testified The applicants, all 6 of them, testified that they have deep emotional, occupational, and family roots in Namibia. That although some of their assets are subject to restraining orders, they have assets in Namibia. They also testified that their passports, some of their passports and identification documents have been confiscated by the Anti-Corruption Commission, and thus they have no means to apply for traveling documents and do not have the capacity to travel. The state, on the other hand, has argued that all the applicants are facing serious charges of more than 317 million Namibia dollars, and that if they are found guilty, the sentences to be imposed will be severe. There is thus a likelihood that the applicants will abscond in order to avoid staying in custody, as Mr. Maren de Klerk has done, and as the Icelandic co-accused have all disappeared from Namibia. So argued Mr. Lutibesi. In my view, the scales as to whether or not the applicants will abscond are equally balanced. I cannot make a finding whether they will abscond or will not abscond. The second consideration relates to the question of whether or not there is a reasonable likelihood that if the applicants were released on bail, they will tamper with witnesses or interfere with the relevant evidence or cause such evidence to be suppressed or distorted. The applicants have proclaimed their commitment not to interfere with the witnesses or with the evidence. The state is, however, of a different opinion. Mr. Lutibesi for the state argued that the state has led evidence which has not been controverted, that the applicants have tried to interfere with this case and with witnesses. He argued that at least 4 of the 6 applicants are also charged with offenses of obstructing the course of justice. One person who was accused of attempting to allegedly bribe on the alleged instructions of Mr. Hatuikulipi, an anti-corruption commission investigator with an amount of 250,000, was on his own confession convicted of obstructing the course of justice. The state further led evidence to the fact that the 4th applicant, prior to his first arrest, and whilst in custody, used an unauthorized device to communicate with a witness and persuade that witness to sign an agreement which will give him protection. The state has also led evidence to the effect that an amount of US 4 million Namibia dollars, which amount, if conservatively converted to Namibian dollars, amounts to anything between 60 and 70 million Namibia dollars, which originated from Norway in respect of revenue derived from allocation of fishing quotas to Namgamor Pesca SA, was paid into the bank account held in the United Arab Emirates to a company named Tundavala, in which the second applicant holds interest. The state tended that its efforts to trace that money has been frustrated. I am thus satisfied that the likelihood that the applicants will, if released on bail, suppress or distort evidence relating to that sum of money is real. In the matter of State versus Timotheus, this court further held that the provisions provided for in the Namibian Constitution, read with Act 5 of 91, are in the public interest and in the interest of the administration of justice. For there shall be no fair trial, as anticipated by Article 12 of the Namibian Constitution, or possibly no trial at all, if a situation is allowed to develop whereby the accused interferes with state witnesses or with evidence. If a reasonable possibility exists that this might be the case, it will be in the best interest of the administration of justice then not to take the risk and allow such accused out on bail, even where it shows that they are likely not to abscond. And close quotes. I agree with the state that on this point that all the applicants have not satisfied the court that if they are released on bail, they will not distort or suppress evidence, and thus the likelihood that they will interfere with evidence is real. The third factor to be taken into consideration is how prejudicial it may be for the applicants in all circumstances to be kept in custody by being denied bail. In this matter, it is undeniable that the applicants have been in custody for a period exceeding 2 years. Mr. Engelbrecht referred me to the Botswana case of Stimela and another versus the state, where the Ngake judge said the following. It seems clear to me that a prison environment may not be necessarily conducive to prepare one's defense. Prosecution is in some respects similar to a boxing match. It will seem ex facie unfair that one of the contestants in the boxing match should remain chained whilst the other is free to roam freely in search of the evidence that can nail the chained contestant without the said contestant being granted the opportunity to do likewise. The principle of equality of arms suggests that as much as practically possible, the protagonists, accused and state, must be afforded equal opportunities to gather evidence that must support their respective cases. The petitioners are already serving prison terms before their conviction or acquittal. It is also too easy to say imprisonment for a few months is nothing out of the ordinary. In my view, even 1 day in prison is one too many. It is worse if the detention before trial takes many months. If it exceeds a year, it becomes unacceptable in a constitutional democracy that places high premiums on the liberty of individuals. While the sentiments expressed by Justice Dingake, accord with the principles of democratic, constitutional democracy, one must not forget that in life there is never a one-shoe-fits-all-sizes situation. Each case must be determined on its own merit. The personal circumstances, that is their health, their family relations, their employment, and the business environment which the applicants place before me, are neither unusual, nor do they singly or together warrant a release of the applicants in the interest of justice. Taking all the evidence into consideration and weighing that evidence against the applicant's personal circumstances, together with the submissions on their behalf, I am satisfied that the applicants have failed to prove that it will be in the interest of justice to grant them bail. To the contrary, I hold the view that the administration of justice will be prejudiced if the applicants were admitted to bail. For the reasons set out in this judgment, the applicant's application for bail is dismissed. That's the judgment. Court would rise.